Shalom,
Om Swastiastu.
Namo Buddhaya.
Good morning to all the honorable guests, speaker, and our moderator.
The Honorable Professor Dr. Haji Joni Emirzon, S.H.M.Hum, as Dean of Faculty of Law, Universitas Sriwijaya.
The respectable Dr. M. Syaifuddin S.H.M.Hum, as Vice Dean for Academic Affairs of Faculty of Law, Universitas Sriwijaya.
The respectable Vegitya Ramadhani Putri, S.Ant. M.A, as Vice Dean for General Affairs and Finance of Faculty of Law, Universitas Sriwijaya.
The respectable Dr. Zulhidayat S.H.M.H, as Vice Dean for Student Affairs and Alumni Relation of Faculty of Law, Universitas Sriwijaya. The respectable Rector of Universitas Taman Siswa, Desfitna S.A. M.Si.
The respectable Director of Universitas Palembang, Dr. Ali Dawir S.H.M.H. The respectable Dean of Faculty of Law, Universitas Palembang, Dr. Ardiana Hidayah S.H.M.H.
The respectable Dean of Faculty of Law, Universitas Taman Siswa, Dr. Rika Destiny Sinaga S.H.M.H.
The respectable the Director of Sekolah Tinggi Ilmu Hukum Sumpah Pemuda, Dr. Haji Firman Freddy Busro S.H.M.Hum.
The respectable the Dean of Faculty of Law, Universitas PGRI Palembang, Dr. Desi Wardiah M.Pd.
The respectable the representative of BANI Palembang, Dr. Insinyur Haji Ahmad Rizal S.H.M.H. FCB ARP FII ARP.
The respectable Managing Partner of JA Institute of Law, represented by Hermanto S.H.M.H.
The respectable all lecturers of Faculty of Law, Universitas Sriwijaya.
The respectable speaker for today international seminar, Mr. Mantan Young, it's already in Zoom. Dr. David Pradan,
Dr. Ilyana Binti Cerosli, and Dr. Meria Utama SH. Also all the participants that has gathered here today.
First of all, let us praise the mighty God for all his blessing, so we can gather here in a good condition. The participant in today's event.
International seminar with the theme
The challenge of using arbitration in the era of society 5.0. Let us start today event by singing the national anthem, Indonesia Raya, and hymn of Unsri, which will be led by Miss Jihan Fadilah. To Miss Jihan, the time is yours. To all the audience, you may please to stand up. Hymn of Unsri.
Universitas Sriwijaya, lama kemajuan bangsaku, dengan falsafah Pancasila, mengabdi kepada Ibu Pertiwi, ilmu alam pengabdian, untuk menerangi alam semesta, dengan semboyan pengabdian, ke arah kejayaan abadi.
Disclaimer. Kami minta maaf untuk salah penyebutan nama dekan, rektor dari PGRI tadi, yang PGRI tadi salah namanya. Misspelling boleh. Kami our respectful, sebutin lagi our respectful. Yang sering pada misspelling. Our respectful Dr. Adila Azani Surya.
All the audience, you may please to have a seat.
Ramadinata di Surya. Dekan Fakultas Hukum Universitas PGRI dan Wakil Rektor Vice Dean for Vice Rektor. Atau nggak usah dekan aja, dekan Fakultas.
di Surya saya. Disclaimer, we are sorry for misspelling for Dean of Faculty of Law Universitas PGRI Palembang, the respectable Dr. Ramadinata di Surya, S.H.M.H. Our next agenda is the opening prayer will be led by Mr. Taroman Pasha, S.H.I.M.H. To Mr. Taroman, the time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. Let us pray that this activity will go on without any problem. I will guide the prayer according of Islam. For choice of other religions, please adjust. Na'udhu billahi minasyaitanir rajim. Bismillahirrahmanirrahim. Alhamdulillah Rabbil Alamin. Wassalatu wassalamu ala ashrafil anbiya'i wal mursalin wa ala alihi wa sahbihi ajma'in. Hamda syakirin, hamdan na'imin, hamdan yuwafi ni'amahu wa yukafi'u mazidah. Ya Rabbana lakal hamdu kama yanbaghi li jalali wajhikal karimi wa 'azimi sultanik. Allahumma salli wa sallim ala sayyidina Muhammadin wa ala ali sayyidina Muhammad. اللهم صل على سيدنا محمد طب القلوب ودواعها وعافية الأبدان وشفائها ونور الأبصار وضيائها وعلى آله وصحبه وسلم. اللهم اجعل جمعنا هذا جمعا مرحوما وتفرقنا من بعده تفرقا معصوما. Ya Allah, Almighty God, by giving that thanks to your presence for all the grace and gift that you have given to us, so that we can be present in this room in the international seminar activity with the theme The Challenge of Using Arbitration in the Era of Society 5.0. Then make our activity an activity that bring together good. Ya Allah, make every discussion, every idea, every thought that emerges from this seminar become useful which we can put into practice in the life of the nation of state, especially in developing a better arbitration system in this fast-paced era. Ya Allah, grant us who are present in this room, especially the speakers in this international seminar, health, happiness, and glory. God is most forgiving. Forgive our sin, parent, teacher, and lecturer in the academic community of the Faculty of Law in particular, and our leaders. God Almighty grant, in the end, we believe that you are the Almighty who grant all our wishes and prayers. Please grant all our prayer and requests. Amin. Rabbana zalamna anfusana wa illam taghfir lana wa tarhamna lanakunanna minal khasirin. Rabbana atina fid dunya hasanah fil akhirati hasanah wa qina adzaban nar. Sallallahu ala sayyidina Muhammad wa ala alihi wa sahbihi wa sallam walhamdulillahi rabbil alamin. Assalamualaikum warahmatullahi wabarakatuh.
The next agenda is welcoming speech by Dean of Faculty of Law Universitas Sriwijaya, Professor Dr. Haji Joni Emirzon S.Ant. To Professor Dr. Haji Joni Emirzon S.Ant., the time is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi. Peace be upon us all. Shalom, Om Swastiastu, Namo Buddhaya. Ladies and gentlemen, today is I think this is very good, our meeting here. First of all, let us so far grateful our God Almighty for blessing and international seminar. The challenge of using arbitration in the era society. 5.0. This is the first time our collaboration between Faculty of Law, University, Sriwijaya University, and then BANI. BANI is arbitration board, National Bench Board, Palembang. We are 7 BANI in Indonesia: Jakarta, Medan, Palembang, Jambi, Bandung, and then Surabaya and Denpasar. And then Faculty of Law, Palembang University, and then Faculty of Law, Taman Siswa University, Sumpah Pemuda School of Law, Faculty of Law, Universitas, PGRI University, and JA Institute of Law. JA is short for my name, Joni Emirzon. Okay, ladies and gentlemen, allow me send it greeting to outstanding speaker. There are 5 speakers today. The first, Men Teng Young, Ph.D., Faculty of Law, University of Macau. Welcome to Palembang. Mr. Welcome to Palembang by Zoom. How are you?
Fine. Thank you.
You're welcome. And then Dr. David Pranang, Faculty of Law, Jawaharlal Nehru University, India. Welcome to Palembang. I think we are almost the same. India, Indonesia, almost the same. It's been Padang, like India. I'm from Padang. My girl from Padang. And then Dr. Liana binti C. Rusli, Faculty of Law and International Relations, University Sultan Zainal Abidin Malaysia. Selamat datang. Udah menjadi saudara kita. Thank you for your. Kemudian Dr. Insinyur Haji Ahmad Rizal SH M.Hum FCBRB VRB BANI Arbitrator. The next, Pak Rizal. And the last, Dr. Meria Utama, S.H.L.M, Faculty of Law, Universitas Sriwijaya. Thank you for all speaker ya. And then BANI Palembang, Bapak Manto, Hermanto ya, S.A.M.H ya. Then Director of Palembang University, ya, thank you. Ya, alumni kita juga. Dan Rector of Universitas Taman Siswa, PLT ya Ibu, selamat Bu ya. Good luck ya, for your. Dan Head of Sumpah Pemuda School of Law, Firman, Dr. Firman, ya. Oh, dan Director of PGRI Universitas Palembang, ya. The Dean of ya, ya. And the Manager Partner of the Institute of Law and Partner, and all deans of the Faculty of Law from partner and invited guests, and then all vice dean at the Faculty of Sriwijaya University, and then lecturer and my student, and other participants. Thank you for participation today. I think this is very good for us, because this collaboration is the first time, and then I want to discussion is more and more we have information between us, maybe from Ibu Maria, Ibu Liana, and then Pak David, I think say Pak David, I call you Pak David. Pak David has been sure, Mr. David, This tema is very good for us, because arbitration is good for this settle about business conflict, and then it is we are in era 5.0. It is, I think, our faculty, not only Faculty of Law, economic, also needs this information. Oleh karena itu, therefore, thank you for committee, have hard work for this activity, Ibu Helena, CS, Ibu Rizka, and others, So they use arbitration in society 5.0 era present and carrying out complex challenges, primarily due to the need to align conventional legal practices with fast-moving technology development, society 5.0, and vision in highly intelligent and connected their technology and seamlessly integrated into all areas of life, which requires arbitration process to adapt accordingly. This includes embracing innovation such as virtual hearing, digital documentation, artificial intelligence, and blockchain. While these advantages can make dispute resolution more efficient, accessible, and cost-effective, they also raise important concerns, particularly regarding data protection, cybersecurity risks, and ensuring fair access for all parties. Furthermore, current legal system and regulation may not be fully prepared to manage these changes, leading for potential gap in consistencies in implementation. Legal institution and professional must work to update arbitration framework while preserving core value while neutrality, fairness, and transparency. Ultimately, the challenge lies not just in integrating new technologies, but in doing so in a way that support justice and trust in arbitration process in an increasingly digital society. Once again, I extend my sincere thank you to everyone for your participation. I hope that today's discussion will deepen our understanding and foster stronger partnership among our institutions. Contribution to the advancement of legal education practice toward a more equitable and improvement society. With great pride and sense of optimism, I officially declare that opening of this seminar, the challenges of using arbitration in the era of society 5.0. I hope this event proved to be insightful, productive, and inspiring for everyone involved. Thank you. Wassalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sehat semua. Ya. Terima kasih.
Our next agenda is certificate and symbolic handover implementation agreement, Faculty of Law Universitas Sriwijaya and event partners to the respectful representatives of Faculty of Law Universitas Sriwijaya and also partners. BANI Palembang, Universitas Palembang,
Universitas Taman Siswa, Sekolah Tinggi Ilmu Hukum Sumpah Pemuda, Universitas PGRI Palembang, and JA Institute of Law. The time is yours.
We kindly inviting all of the partners to be here with us.
We please to Prof. Dr. Haji Joni Emirzon S.M.Hum will come forward to give the certificate to the speaker. To the speaker.
Lautan hanya kolam susu, Iva Unsri yang selalu di hatiku. Iva Unsri bebas dari korupsi, birokrasi bersih siap melayani. Orang bilang Eva Unsri kampus merah, merasa separuh warna bendera kita. Kami yakin pasti Eva bisa wujudkan mimpi tanpa batas. Eva Unsri, saya cinta. Di sini masa depan kita. Kita raih mimpi kita. Eva terus maju bersama. Belajar serius jadi juara. Dengan semangat kita bawa bendera. Bangun bangsa, bangun jiwa raga. Di Eva Unsri kita melangkah. Kampus merah tempat berbagi mimpi. Dengan hati tulus kita bersaksi. Birokrasi bersih melayani. Eva Unsri terus berbakti. Eva Unsri, saya cinta. Di sini masa depan kita. Kita raih mimpi kita. Eva terus maju bersama. Eva Unsri, saya cinta. Di sini masa depan kita. Kita raih mimpi kita. Eva terus maju bersama.
Foto dulu mereka, abis ini baru kalian panggil speaker. For the speakers,
Gak usah foto kalau gitu Za. Jadi langsung aja
speaker,
pemberian sertifikat kepada
speaker.
Unsri, Unsri,
David sama
Eva Unsri. Bukan laut dan hanya kolam susu. Di Eva Unsri yang selalu di hatiku. Eva Unsri.
kalau jangan pakai ya back to
Guys, foto bersama. Foto bersama.
Lautan hanya kolam susu. Eva Unsri yang selalu di hatiku. Eva Unsri bebas dari korupsi. Birokrasi bersih siap melayani. Orang bilang Eva Unsri kampus merah, merah separuh warna bendera kita. Kami yakin pasti Eva bisa wujudkan mimpi tanpa batas. Eva Unsri, saya cinta, di sini masa depan kita. Kita raih mimpi kita, Eva terus maju bersama.
For the speakers, please come forward.
Jangan dulu gitu. Langsung.
We invite all speakers to come here. Please, we invite them. Please come forward. Jadi, we invite to all. Ini mau ini nggak lanjut kan? Iya, the next agenda is giving certificate.
The next agenda is giving certificate to our speaker. First is giving certificate via online to our first speaker, Manteng Young Ph.D. Next is giving certificate to our next speaker, Dr. David Pradan, that will be given by Professor Dr. Haji Joni Emirzon, S.Ant. Ini tidak ada lagi.
Prof Joni juga.
Ibu.
Ini aja, dua Prof Joni, duanya lagi Pak Cecep.
Iliana, Pak Joni baru. Oh ya udah lama.
Prof Joni lagi baru Pak Cecep. Iya.
Next is giving certificate to our third speaker, Dr. Iliana binti Cez Rosli, that will be given by Professor Dr. Haji Joni Emirzon, S.Ant. Tidak. Next is giving certificate to our next speaker, Dr. Insinyur Haji Ahmad Rizal, SMH, FCBRB, FERB. Next is giving certificate to our next speaker, Dr. Maria Utama, SH LL.M, that will be given by Dr. M. Syaifuddin. Pak Nian.
Dr. Iliana, the gift to Dean of Faculty of Law. Dr. Iliana prepare gift for the Dean of Faculty of Law, Unsri.
Dr. Iliana prepare the gift for Dean of Faculty of Law Universitas Sriwijaya. And also a certificate for our moderator.
Next is group photo, which will be accommodated by our respectful committee.
Masuk ke sesi. Ya, tunggu mereka duduk dulu. Thank you for the photo session. Foto bersama?
Ini sama partisipan ya?
Iya, partisipan. Foto bersama.
To all audience, you may be pleased to stand up for the photo session.
Ini podcast.
Iya.
We continue our agenda by opening session for seminar by our moderator. It's an honor to introduce today's moderator, Ms. Raisita Zilzianda, S.H.M.H. She's a lecturer of law in Universitas Sriwijaya. She holds a Bachelor of Law degree from UIN Raden Intan Lampung and a Master of Law from Lampung University, where she was recognized as the best graduate student in both programs.
Her academic journey is marked by excellence and dedication, including receiving awards such as the Best Mini Test Award from the Faculty of Law and representing her university in National Constitutional Debate Competition, including at the Constitutional Court. We are delighted to have someone of her caliber to guide today's session. Please welcome Miss Rasita Ziljinda.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. The Honorable Professor Dr. Haji Joni Emirzon, S.H. M.Hum, as Dean of Faculty of Law, Universitas Sriwijaya. The respectable Dr. M. Syaifuddin, S.H. M.Hum, as Vice Dean for Academic Affairs of Faculty of Law, Universitas Sriwijaya. The respectable Hermanto S.H. M.H., representative of BANI Palembang NJ Institute of Law. The respectable Dean of Faculty of Law, Universitas Palembang, Dr. Ardiana Hidayah S.H.M.H. The respectable Dean of Faculty of Law, Universitas Taman Siswa, Dr. Rika Destini Sinaga S.H.M.H. The respectable the Director of Sekolah Tinggi Ilmu Hukum Sumpah Pemuda, represented Dr. Haji Firman Freddy Busro S.H.M.Hum. The respectable the Dean of Faculty of Law, Universitas PGRI Palembang. The respectable all lecturer of Faculty of Law, Universitas Sriwijaya. The respectable all of the speakers for today international seminar, Dr. Meria Utama S.A. LL.M. as the Associate Professor, Faculty of Law, Universitas Sriwijaya. Dr. Iliana Binti Cherosli, Dr. David Pradan, Mr. Manteng Yong, Ph.D., and also Dr. Insinyur Haji Ahmad Rizal, S.A.M.H., FCF, FEER, and all of the participants that has gathered here today. Good morning, ladies and gentlemen. In the Society 5.0 era, where advanced technology and human focus, innovation is closely connected, arbitration encounters obstacles like handling digital evidence, safeguarding cybersecurity, and upholding fairness in online hearings. To stay effective, transparent, and applicable in this fast-evolving digital world, conventional arbitration practice need to adapt and transform. Ladies and gentlemen, I'm Rasita Ziljinda as a moderator for the international seminar today with a theme, the challenge of using arbitration in the era of the Society 5.0. All right, ladies and gentlemen, before we started our seminar, let me inviting our distinguished speaker today that join us in Zoom and in person with us right now. First of all, we have Sir Manteng Yong, Ph.D., join us with Zoom, and the second, Dr. David Prada, and the third, Dr. Liliana Binti Cherosli, Dr. Insinyur Haji Ahmad Rizal, S.H.M.H. FCBR, FEER, and Dr. Meria Utama, S.A.L.M. We kindly invite the speaker to come forward to be here right now.
PowerPoint will be given by them, right?
Yeah, that's okay. That's okay. You can stand there or you can speak here. All right, we kindly sorry for the Dean of Faculty, the respectable Dean of Faculty of Universitas PGRI Palembang, Dr. Ramadhani di Surya S.M.H. We kindly sorry to say sorry because we haven't said for the honorable and the respectable. All right, so ladies and gentlemen, let's move on to the next speaker. Five of our speakers were present with us in this morning, joined via Zoom, and in person right now with us. Ladies and gentlemen, the speaker has appeared before us via Zoom that we have Sir Manteng Yong, Ph.D. Good morning, sir.
Hello, good morning.
All right. Okay, Sir Manteng Yong is an assistant professor at the University of Macau, Faculty of Law, and coordinated the Master of Law in Macau Law and Practice program. He earned his PhD in private law from the University of M.Hum, focusing on civil liability in traditional Chinese medicine. His research spans medical law, bioethics, and tort law, with numerous publications on informed consent, advanced directives, and NI in healthcare. In addition to his academic work, he has served as a legal advisor and notary for the Macau Health Bureau and is active in international legal forum. Please welcome Sir Manteng Yong, Ph.D.
Thank you. Can you hear me, right?
Yeah, we can hear you.
Okay, thank you for the invitation, especially for the invitation of Professor Ali, Jambi University. First of all, I want to say happy birthday to Professor Ali. Today is your birthday. Happy birthday. Today, my presentation, I want to share my slide. I hope you can see the slide, right? So you can see the slide or you, I'm not sure if you can see the slide.
We can clearly see that.
Okay, thank you. So today my topic is about traditional Chinese medicine, and I just want to combine this concept to telemedicine. Especially I want to talk more about AI and based on Macau law. So after my presentation, maybe you can think about Indonesian law, because the ethics or the issues, challenges here, maybe in Indonesia, you can also see the same problem. Actually, I presented this presentation in Hong Kong. I just changed the content to combine this presentation to arbitration and mediation, because I want to have some match with this international seminar of today. So I just add some elements, especially consumer arbitration and medical dispute mediation. So this is my topic for today. And you can see the keywords here, even though it is about traditional Chinese medicine, but in my opinion, the problems here can occur also in Indonesia, because in Indonesia, just now I just searched on Google. In Indonesia also have traditional medicine, right? Shamu, I think the pronunciation is Shamu, herbal medicine in Indonesia. So the problems can occur also in Indonesia. So I'm not sure if you have the law of telemedicine in Indonesia, but it is very important. We use telemedicine, especially for the COVID-19 period. So let's start my topic. So this is the content of my topic. Step by step, for example, in the introduction, I will tell you my research purpose, especially some research questions about my study. In this page, I just want to emphasize that for traditional medicine, especially now my topic about traditional Chinese medicine, many Western countries still do not believe in traditional Chinese medicine. I think the same situation occurring in Indonesia, right? Western countries do not believe in traditional medicine in Indonesia. This is the Western countries' perspective. You can see many news, literature, studies, research about the doubts or questions about traditional medicine. Actually, my previous PhD study, I studied in Portugal, and I wrote my PhD in Portuguese language. And this is my PhD published in Portuguese publisher. It is about traditional Chinese medicine, especially concentrate on civil liability, but based on Portuguese legal system. In this study, I emphasize one point that we cannot use, and it is not fair, it is not correct that we use the methodologies of Western medicine to validate the efficacy or security of traditional Chinese medicine. And also, we can use the same ethics or same philosophy in Indonesia, especially for Sumpah, this herbal medicine. So in this study, I defended the contrary position against the Western perspective. We cannot use the methods of Western medicine to validate the efficacy and security of traditional medicine. But the question is that this credibility exists in the Chinese community, also exists in Indonesian community, right? Especially for herbal medicine. We believe in Chinese community, we believe in traditional Chinese medicine, just like in Indonesia. You believe in herbal medicine, Shamu, right? So concentrating on the context of Macau, I hope you know where is Macau, near Hong Kong, and we, Macau residents, we feel high levels of trust in traditional Chinese medicine because we are in the Chinese community. You can see on the left-hand side, we have the data about hospital outpatient consultations, and the right-hand side, you can see the data about consultations at private clinics. On the left-hand side, you can see the percentage about Chinese medicine, 12.4%. Even though it is a small percentage, you can see it is higher than other percentage of other medical department in a hospital. For example, internal medicine, general surgery. So Chinese medicine is also very important in hospital. On the right-hand side, you can see the percentage, 37.7% Chinese medicine occupy a high percentage of consultation at private clinics comparing with other area. So we can see Macau residents reveal high levels of trust in traditional Chinese medicine, contrary to the perspective of Western countries. So how about the laws in Macau? Actually, we have traditional Chinese medicine law number 11/2021, and also we have consumer protection law number 9/2021. But this consumer protection law excludes clearly medical service, so we cannot use this law to apply something to traditional Chinese medicine. In case of dispute, we need to apply Medical Era Act in Macau or Civil Code in Macau, especially contract law, tort law. So combining the two red colors, we have in Macau traditional protection of patients. I here use patients, this expression, because we cannot legally understand patients as consumers, because as I mentioned before, consumer protection law excludes clearly medical service. So legally in Macau, patients cannot considered as consumers. If we combine telemedicine, in Macau, actually we do not have any legislation about telemedicine. So combining these three concepts, we can say that in Macau, we don't have modern protection of patients. So my research, my study here is trying to combine traditional Chinese medicine, consumer protection, and telemedicine. So here, some research questions in my study. Should patients or should traditional Chinese patients be considered as consumers? This is the first and main and relevant question that we need to resolve firstly. And second question, do we need telemedicine in Macau? Or you can ask yourself, if in Indonesia, there is no telemedicine law in Indonesia. You can ask yourself if you need telemedicine law in Indonesia. And how to resolve the cross-jurisdictional regulation challenges. As you know, if we use telemedicine, sometimes the service can outside one jurisdiction. For example, in Macau, we can use telemedicine service, but the patient can be outside Macau, or telemedicine service outside Macau, but the patient in Macau. So this is the problem of cross-jurisdictional regulation challenge. So the first question, should we consider patients as consumer? My question, this question is very important, and my answer is yes, but only in certain situations. And you can give me some comment if you do not agree with my perspective, because later I will show you the divergency in the doctrine. Here I just want to show you and mention again that Macau's law gives a negative answer, because we have consumer protection law. As I mentioned before, we in this law excludes clearly medical service. So we cannot consider patients as consumers legally. But in doctrine, if you do well the literature, you can see the divergency. On the left-hand side, you can see some studies, some research consider patients as consumers. But on the right-hand side, you can see other studies, other research consider patients not as consumers. So we can see here in doctrine the divergency about this question. Even though legally, we are very clear in Macau, we cannot consider patients as consumer. And my position is in the right-hand side, pro-consumer, but not absolutely. I will tell you why. Because sometimes patients meet the core characteristics of consumer. Especially sometimes patients can be purchasers of services for personal use. So what situation, at least in elective and non-emergency treatments? So here I want to show you two different situations. The first situation is on the left-hand side, emergency treatment. As you know, what is emergency treatment? It occurs normally in emergency room, emergency department of a hospital. So not the case of traditional department or traditional clinics. In this case, on the left-hand side, we cannot consider patients as consumers. So they only can be protected by healthcare legislation. But the situation is different on the right-hand side, especially in elective or non-emergency treatment. And this is the case of majority of traditional Chinese medicine, and also of Shamu in Indonesia, right? So in this case, in my opinion, patients can be considered as consumers. And in this case, they can be protected by consumer protection law, at the same time by healthcare legislation. So I just want to emphasize here that if we consider patients as consumer status does not undermine professional ethics. So I just want to emphasize that this status complements the professional ethics by adding more and more duties to doctors. So in my opinion, the law number 9/2021 in Macau should not exclude medical service. So in my opinion, at least we need to accept elective and non-emergency treatments included in consumer protection. So in elective and non-emergency treatment, we need to consider patient as consumer, because some right in this law can protect well the patient as consumers. So we have another question. We have another question. In case of dispute, a person, when we consider this person as patient, and at the same moment we consider the patient as consumer. So here I show you person, consumer, patient. Appeals to consumer arbitration or medical dispute mediation. Why I raise this question? Because in the Macau context, we have two specific centers. On the left-hand side, you can see the Macau Consumer Mediation and Arbitration Center, only for consumer protection. And on the right-hand side, you can see Medical Dispute Mediation Center. So the question is, in case of dispute, if we at the same time consider a person as consumer and also as patient, which center we need to appeal to for more protection of this person? This is the situation that we need to resolve in Macau, maybe in Indonesia also. My opinion is that we need to identify if the dispute relates to consumer protection issue or healthcare issue. So here I show you the two situations and one example about right to know. Maybe you know better right to know, right? On the left-hand side, we have consumer protection issue. And if the consumer use his or her right to know, maybe sometimes he need to know the price of medical service, the title of a doctors, and specialization of doctors, the service content, and more as a consumer. On the right-hand side, you can see the right to know in healthcare issues, especially this concept, right to know from informed consent. So in healthcare issues, the patient needs to know the risk of a medical service, alternatives of medical service, a clear and detailed explanation of diagnosis, and more about healthcare issues. So you can see here, we use the same concept, right to know, but on the left-hand side, we have specific issues to protect, but on the right-hand side, for the same concept, right to know, but we have healthcare issues for protection. So if in case we face the issues on the right-hand side or on the left-hand side, we use the different mechanism for the dispute. For example, if we face a consumer protection issue, in Macau we use consumer, maybe consumers appeal to consumer mediation and arbitration center. On the right-hand side, if we face a healthcare issue, maybe the patient as a consumer, even though we consider them as consumer, but as we face healthcare issues, they need to appeal to medical dispute mediation center. So the second question is, do we need telemedicine legislation in Macau? Yes, my answer is yes. So I propose the telemedicine law in Macau and its foundational elements here. You can discuss and tell me more if these foundational elements are relevant or significant or not. About the situation in Macau, especially the timeline of questioning the telemedicine applicability, I used COVID-19 as the timeline division. Before COVID-19, actually, Macau residents questioned about the applicability of telemedicine because we do not have any legislation of telemedicine. During COVID-19 period, the Macau government began discussing the applicability of telemedicine. After COVID-19, actually, Macau government began using telemedicine in certain situations. Especially here, I show you, for example, telemedicine. The Macau government applies telemedicine to elderly residential care, and on the right-hand side, this example, you can see expert teams between them using telemedicine consultation. So we use telemedicine mechanism after COVID-19. So as we do not have the law now, so it seems telemedicine is only legal with authorization of the government, especially of the Macau Health Bureau. But we still have questions, we still have doubt. If we do not have authorization of the government, do we have is it legal or illegal using telemedicine in Macau? So legislation is necessary. So we need a law about telemedicine to clarify the legalization of telemedicine in Macau. And also if in Indonesia there is no telemedicine law in Indonesia, maybe you need also a legislation to clarify the legalization of telemedicine. So my study proposes a law with the following relevant elements. Especially we need to have definition, especially we need to define what is telemedicine, what is telehealth, is there any difference between telemedicine and telehealth, and specify which kind of situation or the types of service covered by telemedicine, and also licensing, accreditation. We need a law clarifying the licensing, especially for traditional Chinese medicine platform, and also accreditation for individual practitioners. And also it is very important data protection and privacy. We need to extend the personal data protection law to telemedicine. Otherwise, we will have doubt or question about the applicability of personal data protection law to telemedicine, and more contractual consent requirements, and also very important quality assurance and technical standards, especially set the minimum technical requirements for video consultation platforms to ensure reliable and the most important is secure service delivery. And on the left hand side, you can see the e-prescriptions. This part is also very important. After telemedicine service, maybe the patient or consumer can go directly to pharmacy without any paper, and the pharmacy has a system in the computer to see the e-prescription and issue the medicine or medication to the patient or consumer. And also governance, compliance, and enforcement, and especially liability malpractice in case of liability, in case of medical malpractice, and also what will be the dispute resolution, arbitration, mediation, or appeal directly to the court. We need to clarify these points. So, if we have telemedicine law in Macau, we face another challenge, especially cross-jurisdictional regulation challenges. For example, the patients in Macau have the telemedicine service in China. So here we can see the situation of cross-border challenges. So we do not know which law we apply. We apply Macau law or Chinese law. This is the question. So I propose bilateral or regional agreements between two parties, and also its necessary elements. So I just want to emphasize again here the situation. At least in the following situations, we have questions about whether Macau law or foreign law should be applied, especially in case of medical malpractice.
Mr. Mantegnon,
yes.
sorry.
Yes.
We only
Yes.
maybe just like 15 minutes, so maybe we have 5 minutes more for the presentation.
I will finish in 2 minutes.
All right, thank you so much.
Thank you. And sorry for the extension of time. And so here you can see the red color and yellow color. Red color is the situation of doctors outside Macau but patients in Macau. This is a cross-border question. And in the yellow color, you can see patients outside Macau but doctors in Macau. So at least in these two situations, we have questions about whether Macau law or foreign law should be applied. If we have agreement, especially in the field of telemedicine, we can think about the agreement, the regional agreement between Indonesia and Macau. But this is another study. Cross-border telemedicine requires mutual recognition agreement with aligned regulatory frameworks to resolve jurisdictional conflict and ensure practitioner accountability. So my study, I want to begin for Macau. I want to begin first with the Greater Bay Area. I hope you know where is the Greater Bay Area, near Macau, with mechanisms similar to EU. So here I just want to emphasize that I use the EU model, European Union model. I am not saying that I copy-paste the model. I use the EU model to adapt in the situation in Macau, Hong Kong, and China, especially Guangdong province. So here, maybe I do not have enough time to explain one by one, but I just want to emphasize here, especially the number 2, cross-border recognition of prescription. Actually, in EU, they have laws about cross-border recognition of prescriptions. So we can use the same mechanism to adapt in the context of in Macau, Hong Kong, and China. So you can use the same model to adapt in the situation of Indonesia also. So I do not go through in detail these 4 points. So in conclusion, conclusion number 1, 2, and 3, I hope my study to combine or have some connection between traditional Chinese medicine, consumer protection, and telemedicine. So this is the conclusions number 1, 2, and 3. After these 3 conclusions, we have number 4, especially the cross-border challenges. So I propose bilateral or regional agreement as a solution, and I propose the necessary elements for this agreement. So this is my presentation. Thank you very much, and sorry for the extension of the time that I used in this presentation. Comments are welcome. Thank you very much.
All right, give applause for the Mr. Mantengyong Ph.D. for the amazing presentation. All right, ladies and gentlemen, let me give you some summary for the presentation. The presentation highlights the need of modernized Macau legal frameworks for traditional Chinese medicine or TCM and telemedicine. Non-emergency TCM service should be treated as consumer service, while the lack of telemedicine regulation creates uncertainty. Clear legal guidelines and regional cooperation, especially in the Greater Bay Area, are essential. Distinguishing between consumer and healthcare dispute will help ensure appropriate resolution mechanism. All right, ladies and gentlemen, before we move on to the next speaker, that we kindly inviting our 4th speaker that has appeared before us, Dr. Insinyur Haji Ahmad Rizal, S.H. M.H. F.C.R. F.E.E.R. All right. Thank you so much. All right, we truly appreciate it for Dr. Rizal present today, because despite being unwell, he still made the effort to attend this international seminar. All right, ladies and gentlemen, let's move on to the second speaker, our amazing speaker. He is from Dr. David Pradhan. Dr. David Pradhan is a legal scholar and advocate specializing in arbitration with degrees from top Indian University and a Ph.D. from Jawaharlal Nehru University. He has held academic and research roles in Suriname, Indonesia, and Switzerland, and practiced at the Delhi High Court, an associate of the Carter Institute of Arbitrators in United Kingdom. He is currently a visiting assistant professor at Nusa Putra University and conducting postdoctoral research on arbitration enforcement in ASEAN in India. His work focuses on comparative dispute resolution, arbitration, mediation ethics, and conciliation. All right, ladies and gentlemen, please welcome our amazing speaker, Dr. David Pradhan.
Good morning, respected Dean of the Faculty of Law, Unsri, respected teachers and professors from the Unsri and other universities of Palembang. I remember my guide, Professor B.S. Chimney, with whose blessings I am what I am today. Also, I must thank my mentor in Indonesia, Professor Ibu Ari Budhyarthi, who has been a guiding source throughout my life and in Indonesia as well. Thank you so much. I'm very glad to be here at Unsri. I was told that the time is only 15 minutes, so I will not go in detail. I will just speak in general, but I want to speak about something that concerns all of us. Please note that, is my slide ready? Yeah, okay. So if you put the first slide on, I'll tell you. Yeah, yeah, okay. So my talk is on international commercial arbitration and development in the global south. I'm trying to look at, we are talking about a global world, we are talking about use of technology in arbitration, we are talking about the world becoming a more level field. But as a lawyer who is practicing in the arbitration field, I'm sure others who are practicing will also agree with me. It is not so. There is, in international commercial arbitration at least, there's a lot of issues that we are facing. So when I am giving this talk, I have the usual caveats. What I say is my personal view, does not represent the view of my university, Jawaharlal Nehru University or India, and I claim academic immunity for what I'm about to say. If it hurts anyone's feelings, I apologize from the beginning. So with that said, let's go on to the first slide, please. Yeah, so India and Indonesia are the global scenario is changing. India and Indonesia, among other countries like the BRICS countries, are becoming the new global economic superpowers. And to a large part, the economic prosperity that is coming into these countries, like India is already today the 4th largest economy in the world after US, China, and I think it's Germany, then it's India today. And already scholars are predicting that by 2050, Indonesia will also be among the top 4 highest economies in the world. Now this economic development is very much dependent upon international trade and commerce, international trade in goods and services. Even Indonesia and India are emerging as hubs of international trade. Whenever there is international trade, there are undoubtedly international trade disputes. And whenever there is an international commercial dispute, the way to resolve it, the easiest way to resolve it is through alternative dispute resolution, not going through the courts, but through a mechanism of alternative dispute resolution, such as conciliation, mediation, or in most cases, arbitration, where the arbitrator decides and gives an award and it is enforced by the courts of law. So this is the basic foundation by which we are proceeding. And this is very important because international commercial arbitration is called the grease. It is the lubricant of transnational economic intercourse. Whatever deals, whatever business we are having in globalization today, we are buying something from abroad, it is facilitated by arbitration law. Please, next slide, please. So, international arbitration law, as we know, has been almost, it's almost uniform all over the world because most of the countries have based their arbitration laws, their arbitration acts, their arbitration legislation made by the parliament on the UNCITRAL model law, 1986, which was recently amended in 2006, and the enforcement of this is governed by the New York Convention of 1958, which mandates how the international trade law, international arbitration law is to be implemented. And while we all say that the law is the same all over the world, it is also true, like Roscoe Pound, the jurisprudence scholar jurist, says that law in book and law in action is very different. So although we have an international framework which presents a uniform law for the entire world, in practice, developing countries like India and Indonesia, which are trying to disrupt the power of the powerful countries of Europe and America, are facing a lot of uphill tasks. And this I want to discuss about. The fault is on both hands. It is also on the part of the, the developed countries which are trying to block our economic development in certain ways, and also on our own part. So we'll come on to that. I'll be a little bit fast on this. So there are a lot of problems in this. Main among them are that, next slide please. Yeah. The main problem that I envisage for international commercial arbitration is structural within the framework of the UNCITRAL law and New York Convention, and also within our own countries, the institutions that we have. So this will be a critical analysis of both international legal framework as well as our own institutional laws. Okay, next slide, please. So, this is some data about award enforcement that I want to present to you. The perception of arbitration being an alternative dispute resolution means that it is an alternative to the court system. It is an alternative to the court system. The courts have no role except a very limited role in case of patent, very gross injustice that the courts have to intervene. But, and also we know that the framework is that once an award is given anywhere in the world under the New York Convention, it can be enforced in any country that is a signatory, as if it were a decree of a civil court. It has got binding effect. The decision given in Singapore, it must be enforced in India because both countries are signatories to the same law, to the New York Convention. But what we are seeing in practice is this, that UK has 89% of enforcement. Decisions given in the UK have 89% of enforcement. In Singapore has 92% of enforcement, but in India and Indonesia is 42 and 37% only, which is like dismally low. A decision in arbitral award given in Indonesia is not being enforced by the countries that are supposed to enforce it. This is a new sort of, discrimination that has entered into international arbitration law. Now, what this has done is, there is a lot of dispute that arises. 85% of the disputes that arise in international commercial transaction, they go to arbitration. But maximum of them, when the decision is given by an arbitral tribunal based in a developing country of the global south, they are not being implemented. They are being overruled under Article 5 of the New York Convention. So empirical data shows that, developed countries are not respecting the New York Convention, the mandate to enforce the decision given by the arbitral tribunal when the arbitral tribunal is based in a developing country or a competitor country. If we are competing with another country, there is an element of politics which enters rather than pure legality, which should be the case in these matters. So, despite formal ratification of UNCITRAL standards, we, developing countries of the global south, India, Indonesia, Malaysia, we face a lot of uphill task when it comes to the implementation of the law by countries like America, Europe, and other developed countries. So this is the thing that I want to speak about. Next slide, please. So legal philosophy of it, I don't want to be dwell much on it, but nowadays the neoliberal agenda is fully in force, and all of us are aware of that. Trump and his tariffs unilaterally imposed on countries in violation of all trade laws and etc. But look at Article 5.1e and 5.1b of the New York Convention. It gives a very limited scope that in case of patent illegality, when on the face of it there is a illegality in the arbitral process or a mistake of fact in the arbitral process, then the judicial institutions like the courts can intervene. Otherwise, the arbitral award stands by itself as a final award on the case, on the issue. The courts do not have any role to intervene in it. This provides a limited window to address miscarriage of justice. However, what we find nowadays is that the developed countries are using this clause and introducing new clauses into their arbitration laws to actually stall arbitration awards given by certain countries. Certain countries like India and Indonesia, which are developing, of course, but are also competitors with those countries like US and Europe in many different fields. So whenever there is a competition, there is a clash of interests, even an arbitral award, even after it is obtained, it is very difficult to enforce it. Next slide, please. So some of the problems that I identify structurally in the international arbitral law matrix is that it is a fragmented legal system. We have got many different institutional mechanisms. We have got the UNCITRAL, we have got ICISD, we have got the WTO panels. Nowadays, even regionally, we find that there are certain, regulatory ecosystems that have emerged, and each one of them has a different mechanism. Although all of them claim to be based on the UNCITRAL, there is a little bit of difference between the different arbitral mechanisms. And what this differences between the different rules of the different arbitral bodies does is that it creates inconsistent procedural norms. For example, the procedural norm for the time period between submission of document and hearing in Singapore differs considerably from the same period given in India. Because we say that, oh, it's a very difficult process. And in a society 5.0, which is based on technology, it should be instantaneous. You submit PDF files of your document and you get a next day hearing or within the week. But we find that this procedural delay is making arbitral process, which is supposed to be a quick and sure process for solving problems quickly so that the commercial transactions can proceed smoothly. It is taking more time, just like a court proceeding. So this is another institution. And then what is happening is there is also jurisdictional forum shopping. So we try to see which arbitral body will be more conducive to us. Yeah, and in arbitral agreements nowadays, the arbitration clause is not even containing any the name of the arbitral forum, but is just saying it will be by arbitration, and that creates a judicial forum shopping. Okay, so should I go to Delhi International Arbitration Center? Should I go to Dubai? Should I come to BANI in Indonesia? Where should I go? So whichever suits me, then I will argue for that. So then that matter goes to the court. So what happens is that the developed countries have sort of settled their arbitration law, and now they are trying to transport or export those standards to developing countries and trying to enforce, if you do not listen to these standards, we will challenge your decision in court. This is a fact which happens. I'll give some cases. Next, please. So while UNCITRAL allows the courts to intervene, one of the public policy, in UNCITRAL for setting aside under Article 31 is that the setting aside, 34 is setting aside of the arbitral decision based on public policy. Now, public policy is an ideological fact. It is not a legal consideration. Public policy is decided by the politicians, not by lawyers. We go by law, we go by the jurisprudence, whereas public policy differs in the same country when the government changes, or in different countries based on their public policy. So what happens is that the courts in the global north, they are using this exception to challenge, to negate the arbitral awards given in our countries. So there are some cases. One case is from Egypt, wherein the Republic of Egypt, a developing country, gave an award which was a very logical, rational award, but US refused to enforce it, saying no, it's against our public policy. Next slide, please. So similarly, the Article 36, it allows that there should be a manifest, there should not be manifest disregard for the law. But what we find is that in this case, in which there was a Laos, Thai and Lao joint venture which had a dispute with a US company, the US actually ruled in favor of the US, although the award was given, and refused to enforce. There was a clear case of ideological bias in that. Next slide, please. So even the New York Convention, which is the international convention governing international commercial trade and arbitration, Article 5 has been misused to such an extent, and one of the underlying excuses given whenever developed countries talk about developing countries like India and Indonesia, is that our legal system is either corrupt, or it is underdeveloped, or it is compromised. You actually find these words in the decisions, that the legal system of that country being corrupt, so we will decide on it again. The court takes on jurisdiction of the arbitral award because it says your country is, it's a damning condemnation of the legal system of your entire country by another jurisdiction, which is by another country's legal system, as if they are not corrupt, as if they are not underdeveloped, as if they are not compromised. So some of the examples are already here. The slides will be shared with you. Due to lack of time, I'm not going in detail. Next slide, please. So also what happens is that there is an analysis which shows by Queen Mary University and others, which clearly shows that whenever there is a decision given by a developing country of the global south, north jurisdictions, the global north, the developed countries, they use this public policy argument or underdeveloped legal system argument to negate those decisions. And this is a ubiquitous phenomenon. There are hundreds of cases that can be seen which are still in dispute and much discussed in international commercial arbitration law. Next slide, please. So, but we cannot say that the problem, the fault lies only with the international, the Western countries. The problem also lies with us. So I have tried to identify some issues in Indian law and Indonesian law and compare it with Singapore and Hong Kong to see what problems we have. So in India, although we have the UNCITRAL law, you know, there were two cases, Venture Global versus Satyam Computers, in which India said that we will not enforce a certain foreign award. Of course, that was later remedied, but we are also playing the same game. It is not that they are only playing it, we are also retaliating. So the problem is that when countries play this political game, the field of international arbitration law is getting affected. That is the problem. And Indian courts under sections 34 and 37 of the Arbitration and Conciliation Act, they are also invoking the same public policy argument which was introduced under the ONGC versus Saw Pipes case. We also stole the same argument from them. And if there is, and what we are doing is, what Big Brother America is doing with India, India is doing with younger brother Sri Lanka. If there is a Sri Lankan dispute, we are using public policy argument, using the same arguments. And what we are doing is we are perpetuating the cycle of discrimination and disruption of international arbitral law. Now there is also another problem, is that there is a lack of institutional training in India. If you want to be an arbitrator in India, you have to qualify the Chartered Institute of Arbitrators UK. I had to do it because Indian arbitral institutions which are offering training, they are not recognized. That training is not recognized by other countries. The other thing is that arbitral institutions in India, like the DISC, etc., are run by lawyers. And lawyers have their bar associations. Bar associations invariably have got political affiliations. And because of that, these bar associations in India have turned into ideological contestation areas wherein there is super politicization and disruption within the international arbitral associations as well. So what has happened is, in addition to this, there is lack of government support, public policy, funding for building world-class institutions, where international arbitrations can take place, where disputants from other countries can come for an arbitral tribunal. There is not much money assigned to it. So arbitration by itself is, Indian government swings from day one to day two. One day it promises to enforce arbitration, next day it changes its stance. Yeah, so that is one fact. Next slide, please. So this is something
Dr. David, we only have 2 minutes left.
Yeah. So coming on to Indonesia, I think you have the same problem. In Indonesia also, in your institutions and everything, very much we have the same legal culture. I believe even your BANI has disputes with Lampang and sovereign differentiations and all that. But in Indonesia also, just recently someone sent me a link that go to Australia for training, paying 27 million or something like that, that online training thing. So in Indonesia also, it faces the same problem, lack of government support and disproportionately high disputes in which state is the party. So that is one issue. Next slide, please. Singapore and Hong Kong, which are just neighboring countries, they have a much better regulatory framework and success rate because, firstly, unlike Indonesia and India, they're perceived as apolitical venues and they attract a lot of foreign investment. Secondly, their law is very closely aligned with UNCITRAL. Thirdly, the international arbitration rules of SIAC and HKIAC are very well developed and they have got digitalized systems. Now, this is the 5.0 part. There is a digital system for dispute submission and resolution in both Hong Kong and Singapore, which we sadly lack, and that is where more attention should be paid. And then there is multilingual panels. That is a problem which afflicts Indonesia, that Bahasa is the language, whereas English is the language, and multilingual panels are provided in other judicial forums. Time-bound and very professional service, and there is no ideological politics. That is one thing that is the main marker, I think. And there is also the pro-arbitration judiciary, and courts consistently support enforcement of the international arbitration law. Final slide, please. Next. So I have some recommendations. We should, of course, follow the UNCITRAL law, support of the enforcement of international arbitration. But also we must, now that Indonesia is also a member of the BRICS, we must have more South-to-South cooperation. There should be more training there should be establishment of regional or international or national training bodies and qualifications which are recognized globally. Because we may recognize it within our country, but if we are talking about international commercial arbitration, it is necessary that these should be recognized by other countries. And therefore, I think that the way forward is going to be quite clear for us as we look around. There are some other recommendations also. Next slide, please. So all these recommendations you can read on in the slide. And finally, all the, there is one suggestion that we can establish an Asian conglomerate in the World Trade Organization or other forums where all the developing countries can counter the machinations of the developed countries. Thank you very much for giving me this opportunity. I will address any questions later when the question and answer starts. Thank you.
All right, thank you so much, Dr. David, for the enthusiastic presentation. Oh my God, all right. Okay, let me give you some summary from the presentation. While international commercial arbitration, or ICA, is often seen as an impartial and efficient way to resolve trade dispute, it can reinforce global inequalities that disadvantage developing countries. Nations like India and Indonesia face challenges such as weak enforcement, inconsistent judiciary, poor infrastructure, and bias from the followed nation court. Addressing this issue calls for legal reform, capacity building, regional cooperation, and strong international advocacy. With an uneven strategy, developing countries can push for fairer treatment in the global arbitration system. All right, thank you so much for the enthusiastic presentation, Dr. David. All right, let's move on to our third speaker. She's from Malaysia. All right, Dr. Iliana Binti Cherosli is a senior lecturer and head of the Center for Legal Studies at UNIZA, Malaysia, with a Ph.D. in International Commercial Arbitration and LL.M. from the University of Sussex. Her expertise includes alternative dispute resolution, commercial law, and international law. She has published widely guided postgraduate research and contribute to legal education innovation, actively involved in academic leadership, recognized with multiple awards. Dr. Iliana is committed to advancing legal scholarship and education both nationally and internationally. All right, ladies and gentlemen, please welcome our amazing speakers, Dr. Iliana Binti Cherosli. Time is yours.
Okay. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. And a very, I think, still morning. Yeah. Good morning to all. First and foremost, I would like to thank Universitas Sriwijaya, yeah, and also Dr. Ari from Unja for inviting me over all the way from Terengganu. If you guys are wondering, Terengganu is 5 hours from Kuala Lumpur by car. It's about 550 kilometers from Kuala Lumpur. So I have to take generally 3 flights to get to here. All right, quite far, but yeah, good journey regardless. All right. So our beautiful moderator, Miss Risita, yeah, Miss Risita, and the deans of the law faculties, members of the faculty, our speakers here. We have Dr. Manteng Yong, Dr. David Pradhan, Dr. I.R. H. Ahmad Rizal, and also Dr. Maria Utama from Unsri. Distinguished members, the students, yeah, thank you so much for being here. It is an honor for me and a privilege for me to join this international conference. This is my first time in Palembang, a very beautiful city, I may say, and it's very close to Malaysia. I think the faces, our culture, yeah, and I really like this what is this called? Sampin? Oh. Selendang, yeah, a songket selendang, yeah. Thank you so much. So today, my slides, yeah, okay, here. I was looking for my slides, okay. So today I'm going to speak on the enforcement of annulled awards in international arbitration. Unsri invited me, I think 3 weeks ago, but online, yeah. So I was presenting on the recognition and enforcement of awards in general, but today I would like to go deeper into the enforcement of vacated or annulled awards, awards that has been cancelled by the original state, yeah. here is my agenda for today. Next. I think I need to make a, timer, so I won't. Okay, just 1 second. All right, 15 minutes. Yeah, okay, all right. Okay, so what is international commercial arbitration? I think I can skip this because our distinguished Dr. Pravan, Dr. David has already discussed this. Next. Okay, so when we talk about international or foreign award, okay, that is different than domestic award because the treatment, I believe, in Indonesia, in Malaysia, and India are mainly different. Okay, the courts are giving different treatments to awards, domestic and international awards. So Article 1 of the New York Convention 1958, which is the main convention for international commercial arbitration, define what is a foreign award. So a foreign award is an award that is made in a different country but then enforced in different country. That is what we call foreign award. So that award needs to be made in another territory in order for it to be qualified as foreign award. Next. Okay, and under the Malaysian law, okay, if we refer to Section 2 of our Arbitration Act 2005, okay, our code, yeah. So the arbitration award is international if, first, at least one party has its place of business outside Malaysia, or the place of arbitration or the place where a substantial part of the obligation to be performed is outside Malaysia, or the parties expressly agree that the arbitration is international. So it could be, for example, there are maybe the parties decide to settle the dispute in BANI, and in their contract arbitration clause they say that the arbitration is international. We won't want this to be governed by the law of Indonesia, for example, yeah. So so in Malaysia, that award will be considered as international award, even though maybe the parties coming both from Indonesia, because the parties agree to it. All right, next. Okay, so understanding annulled awards. So we must remember that when we refer to annulled awards, the award that has been cancelled by the state where the arbitration was held. For example, the parties might come from India and Malaysia, but the arbitration is in BANI, in Indonesia, for example. So the supervisory seat or the court that has saying in this matter would be the Indonesian court, where the court where the award was made. So historically, the award that has been cancelled, for example, in Indonesia just now, maybe Malaysia, India, or maybe Macau would have not enforced it. But actually, there are countries that are still enforcing awards that has been cancelled by the original state. That is what the main discussion of my discussion today. Actually, this is a development of my PhD thesis that I did in Sussex, and I've included several recent cases as well. Okay, next. This paper has not yet been published. You do not publish this, please. All right. Okay. So this is a very famous case in international commercial arbitration, the Maximov case. I believe that maybe those that are in arbitration are already aware of this case, but perhaps some background to the students here. Okay, the award was issued by the International Commercial Arbitration Court of the Chambers of Commerce in Russia. Yeah. So that award has been set aside, has been vacated, has been cancelled by the Moscow court. That then has been upheld by the federal and supreme court, the highest court in Russia. But what happened is the parties tried to enforce this cancelled award to 3 different countries. Yeah, first in France, second in Netherlands, and finally in England, in the UK. So what happened in France? Yeah, the court enforced the award. They were using the theory of delocalized theory, where they say that international arbitration is somewhere hanging, not belong to any of the country, so we can enforce the award. Next, Netherlands. What Netherlands say? The court upheld. The Maximov case. The court upheld the decision to enforce the award, but the Netherlands court conducted assessment, i.e. they assess whether it actually go against their principle or not, the public policy or not, and in this case they decided to enforce the award. They said, no, it's okay. There has certain things happen. This is beyond the public policy in Netherlands, so yeah, we can enforce this cancel award. What happened in England's next? Okay, in England, actually they are more, even though they adopted assessment approach, but they are more inclined to not enforce the award because they are relying on territoriality principle. So they impose a heavy burden to the applicant to show that the annulment decision in Russia was made in bad faith or with bias. And here the court says that, oh, you can't prove that, so we are not going to enforce this award. So you can see here there are 3 different treatment by 3 different courts over the cancelled award in international arbitration. Next. Okay, next. Okay. Alright, so this is the legal framework under New York Convention 1958, which all the countries that we just mentioned are the parties to it, including India, Malaysia, and also Indonesia. Yeah. So Article 5 mentioned that 51E, okay, to be specific, the enforcement of award may be refused if the award has been set aside by the competent authority of the seat of arbitration where the award was made. Yeah, and Article 6 mentioned court may adjourn enforcement pending decision of the seat. So, for example, if there is a dispute between India and Malaysia, okay, and the seat is Indonesia, okay, and then maybe Dr. David won the award, and he would like to enforce it in Singapore, no, in Malaysia. So this Malaysian court will say no, we won't enforce this award pending, okay, the decision in Indonesian court. If, for example, I were to apply to set aside the award won by him in Indonesia. So that was what the New York Convention mentioned. However, Article 7 gives favorable right clause, which is allow enforcement under a more lenient domestic law. It says that if the domestic law of that country allow for enforcement, we should allow for enforcement. So it's quite contradicting, isn't it? Okay, and also the word, okay, maybe we can go to next slide. Next slide, please. Sorry, next one ada lagi ke? Oh, I think this is the old slide. It's okay. Can you go back? Actually, I added some of the convention punya rules that last night, okay, to make it clearer. But can you go back? It's okay. I'll just explain it by words. One more slide back. Oh yeah, thank you. Yeah. So the word may, enforcement of the award may be refused. It does not say shall be refused, but may. So the court in different countries, they're interpreting the word may as maybe or may. So it's up to the court in the enforcement seat. So it gives rise to forum shopping. So now in international arbitration, we say that, okay, we would like to go for the easy enforcement of award, that because the international award is recognized for more than 170 countries all over the world. But once the seat cancelled the award, now that person can go to 169 other countries and try to get something from it. Next. Next, please. Sorry. Okay. So theoretically, okay, this is a little bit theoretically, there are 3 approaches, okay, to enforcement of annulled awards that based on my research. Yeah, the first one is territorial, i.e. difference to the supervisory seat. Second is delocalized, i.e. arbitrary awards are autonomous, they are on their own, they do not belong to any state. And thirdly, assessment approach, where the court will review until and unless it kind of interfere with the public policy of that country, then they will not enforce it. Next one. Next, please. Okay, the first approach. Okay. I still have 6 more minutes ya, ma'am. Okay, next. Takut sama moderatornya. Nanti stop. Saya kalau bicara 1 jam pun boleh. Alright, next one. Okay, next please. Sorry. Next, Miss. Okay, thank you. Alright. So, the territorial approach, they respect the principle of sovereignty. Okay, meaning to say, territorial approach will respect the seat where the award was made. For example, if the award was made in Indonesia, we must respect if the Indonesia cancelled the award. So the other enforcement seat should not cancel the award. That's what it says. It based on the legal maxim, ex nihilo nihilo fit. I'm not sure whether the pronunciation is right or wrong, sorry. Which means nothing comes from nothing. So the awards has been cancelled, so why should we enforce it? And once the award is annulled at the seat, it ceases to have any legal existence. Yeah, so it also gives specific difference to finality of the award. So the award is final, okay, because it was actually has been confirmed by the seat of arbitration. This is the first approach. Next one. Okay, so I have several cases, okay, for territorial. The first one in German, in the case of OLG München. In German, the court refused enforcement of the annulled Ukrainian award because they say that once the Ukrainian court has cancelled the award, we will not enforce the award. Regardless, we will not check the decision. It respects the principle of finality in arbitration. Also in Singapore, in the case of PT, First Media and Astro, where the court deferred to the Hong Kong court annulment. So this is actually the two countries that that presented to follow the territorial approach. Next. The second one, we have delocalized approach, which is on the other end. Next. Okay, it promotes the internationality of the award. They say that because the award is international, so nobody can touch it. It's still there. Nobody can touch it. Yeah. So it is justified under Article 7, which says that we must apply to the more favorable principle. And the most famous country to have been using, we have several cases, is France. Next. Yep. For example, in the case of Hilmarten in Putra Bali, where the court enforced awards that has been annulled in the seat. So the French court, they treat international awards as autonomous legal act. And also in the case of Cromalloy in the US, where they enforce annulled awards as the annulment was against US public policy. But this is still a bit of assessment approach there for the US. But we can see the France court, because they have in their code, yeah, to respect the domestic law more than the international law, because the domestic law allow for the enforcement, so they will follow the domestic law. Next, okay, sorry. And this is the third approach, which is the assessment approach. Okay. So the enforcement court must evaluate the annulment reasoning. So it will not go directly to the merit of the award, but rather to check whether the principle, whether the process of the arbitration, international arbitration, it violates due process, it was politically motivated, or it was just based on local peculiarities. So I would like to borrow a support Jan Paulson's ISA and LSA theory. First one, ISA refers to international standard annulments, and LSA refers to local standard annulments, meaning to say, okay, the assessment court or the enforcing court will check, will assess if it violates the international standard, yeah, then only it will not enforce the award. But if it only violates its own domestic, it will the court should not interfere into that judgment or into that award. Next. For example, we have several cases in Netherlands, UK, and the USA. In Netherlands, in the famous case of UCOS, okay, they enforced annulled Russian awards because they say that the award was biased over there. Yeah. Next, the annulment there was some bias in that element, so they did not respect the decision. In the case of Malikov and Egypt in the UK court enforced the annulled award after determining annulment lacked some merit. So the UK court, they go into a more stringent or more strict evaluation of the award. Yeah, if there's some biasness in that award, then they will not enforce the award. The same is the case of UCOS Capital, where it refused enforcement where there is no strong evidence of bias. In the USA as well, in the case of Tomorio, the court refused enforcement where the annulment was justified. Among the three approaches, okay, my paper or my research, I agree with Jan Paulson. I'm happy that I'm happy to support the third approach, the assessment approach, because I do believe there needs to be certain assessment or evaluation to be made in order to protect our own domestic or our own law. So, but when it relates to international awards, we must remember to separate between the international reasons and public policy or domestic reasons. If the award does not involve anything about us, about Malaysia, and it does not actually violate any of the international norms or international public policy, then the award should be enforced. Next. So it should not be enforced. Yeah. So what I say here, there are divergences among national courts on the enforcement of vacated awards. So it makes international arbitration to be unpredictable. And there is this forum shopping where the parties that may be not winning the award, oh, it's 15 minutes, can shop around, can check, and also it shows to us here that there is no harmonization. So all of us are like party to this New York Convention, and some of us to the ancestral model law, but the treatment is different from one state to another. Next. Okay, so there are certain factors influencing judicial decision, i.e. procedural integrity, public policy and committee. Lastly, maybe the recommendations, because we just have 1 more minute, Next. Okay, next. To be honest, in Malaysia, we don't really have case yet regarding this matter. Okay, so my paper suggested to Malaysia that we will adopt the assessment approach. Because when I look at the other case, for example, in the case of Masanang, Sendan Berhad and Sabah Nilam in 2021, very recent case, the court says that the seat of arbitration determines which high court has exclusive supervisory jurisdiction. This confirms the importance of juridical seat where the award was made. So the Malaysian court, while it respected its own territorial jurisdiction, if the award was made in Malaysia, they should have the authority to check the award. But if the award was made in another state, another contracting state, Malaysian court must also respect the decision and check only if it violates international public policy or international irregularities. Next. So I would recommend to follow the assessment award and also to follow the classification of ISA and LSA by John Paulson to strike a balance between sovereignty, committee, protecting our best interests, but yet becoming global best practice. I think that's all from me. Thank you so much, and I welcome any question later on. Thank you.
All right, thank you so much for the great presentation from our beautiful moderator from Malaysia. All right, give me some summary for the presentation before. Enforcing annual awards in international arbitration requires balancing finality and fairness. While the territorial approach upholds state sovereignty, it may undermine trust and justice. The localized and assessment model focus more on fairness but risks inconsistency. The assessment approach offers a middle ground by allowing courts to review normal reason. For Malaysia, adopting this model and clarifying section 391A of Arbitration Act 2005 would enhance its arbitration system and align it with global practice. Moving forward, international coordination is key to ensuring consistent and fair handling of a new award. Alright, ladies and gentlemen, let's move on to our fourth speaker. It's from Badan Arbitrasi Nasional Indonesia, Dr. Insinyur Haji Ahmad Rizal S.A. M.H. F.C. B.R. F.E.E.R. is a seasoned expert in law, engineering, and dispute resolution, holding a doctorate from Universitas Pajajaran. He has served as an arbitrator, mediator, legal advisor, and academic. He is affiliated with organizations like BANI, PAMI, and APCAM, and has played a key role in national energy policy through BPH Migas as a speaker, author, and a leader. Currently, right now, Vice Chairman of BANI Palembang and ERBI, Dr. Rizal is dedicated to promoting legal reform, public policy, and economic development in Indonesia. Alright, ladies and gentlemen, please welcome Dr. Insinyur Haji Ahmad Rizal S.A. M.Hum SCBR FER. Time is yours.
Thank you. Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. I'm glad to meet you here to attend the important seminar this morning. And also it is a honor for me to standing here in front of you, all the participants. And Prof. Joni with Dr. Syaifuddin asked for me to deliver the topic about the development of arbitration in Indonesia in digital era. As an official of BANI Palembang, I will try to share the perspective and the experiences regarding to this topic. Ladies and gentlemen, we know the arrival of the era society 5.0 is no longer matter of choice. It is a reality. We must embrace and navigate it. The rapid advancement of information, communication technology, including AI and Internet of Things, is already continues to reshape our aspect and our life. The growth of e-commerce, particularly in the field of digital business, become a concern, including the settlement of disputes among seller and the customer. Another issue about AI. AI is not only coming, but AI already here. Penetrating AI is very fast and affect many sectors, without exception in the world of legal justice. So regarding about AI and justice, or AI and arbitration, we have a big question here. What role should it play? Furthermore, today's in the digital era, online arbitration is become popular, but we still have a homework actually. How to accomplish the regulation and procedure to the process. Ladies and gentlemen, the issues that I just mentioned you just now is a part of my presentation. And to start my presentation, let me draw your attention to my presentation today. Because limitation of time, maybe I will focus about the BANI rules is regarding the online arbitration. But if you want to ask for the complete presentation, you can ask to the official organizer. You know, online arbitration in Indonesia still have a big issue about the data security and privacy, and then the inequality of access to technology. You know, because Indonesia is too wide, many islands. What do you think if a company in Jayapura area has a dispute with another company in Medan? There is a lack of technology. There is a lack of spreading the internet providing. So sometime the tribunal will have a very big problem when they cannot accept the document from company in Irian, in Jayapura, yeah, depending the company from Medan, that Medan already perform with the high-speed internet. So if the company in Jayapura have a very big data for supporting the evidence, I think it will be a big problem. So it is very limited supporting for the certain area Indonesia that cannot be a success if we go to arbitration online. So the award from the tribunal, I think, will not be make a good or complete resolution the what will be not to balance because of the lack of data from another party with another party. So the challenge of online arbitration in Indonesia, about the privacy, you know, right now an important focus, the context of using technology for online information exchange and transaction is the concern about mis and violation of privacy. Sometime, yeah, if the another party, one party, do not responsibility, yeah, to their data that they already deliver to the tribunal, and then in the another side, the party as a claimant suppose use that data or document to another what we call dispute in another arbitration institutional or to the justice, I think it is will be ruin the ethical of the process. Okay, go on. The opportunities of online arbitration in Indonesia. Yes. Online arbitration, although it is a solution and offer attractive and efficient alternative, because certain time will be solved here, and then we can reduce the operational cost also. With an online platform, online arbitration has the capacity to provide fast resolution because it will avoid unnecessary physical meeting. Yeah. We have an experience because of the limitation of transportation from some city to another city. When we have to make the tribunal physically to examine the object of the dispute, sometimes we need an extra time for this. Yeah, because we have to go to remote area, yeah, to examine the object of the dispute. So if we can just make what we call it application Zoom to the party on the side of the object, I think it is will be make our process of arbitration online become effective. Online arbitration very relevant mechanism in responding to the dynamic of dispute, yeah, because it is already international open mind. I think this accepted cross-border dispute and also cross jurisdiction. The dispute parties are from different countries, and then the main reason that online arbitration is needed because can reduce cost reduction, yeah, loss of transportation and expedition costs. So in this meeting, I want to try to explain what BANI already set up for regulation in online arbitration. In BANI arbitration rule 2025, the regulation of online arbitration already attached in BANI arbitration rule in attachment 2. Next slide, please. Yeah. The electronic arbitration rule in chapter 1, it is about scope and implementation. The rule and procedure can be implemented based on, yeah, 3 reasons. 1, disaster emergency. 2, special circumstances. And then see the party's own choice. Only 3 reasons, yeah, the online arbitration if you want to using the BANI rules. And then the chapter number 2, the next slide, about the agreement of the parties and requests for electronic arbitration. The agreement of the parties must be implemented in a good faith based on cooperative, non-confrontational conduct. And then the parties' agreement is writing, must be in writing. And then the chapter number 3 about the hearing rules and confidentiality of the hearing. The parties are required to consistently and compliantly implement the BANI electronic hearing rules of conduct, which include prohibition from recording the hearing in any form. Only secretary can only record the process of the arbitration. Those who are listed in the attendance list and meet the requirement based on this provision may attend the hearing electronically and are prohibited from being attended by other persons who are not entitled and or authorized under the BANI arbitration rule. Only principal or the lawyer can attending the tribunal. And then in the event of the arbitrator, the parties and witnesses will use the assistance of third party in such as a technician or operator to purpose operating the digital platform. Then the person concerned is obligated to make a power of attorney of assignment to the said third party. Because you know, the tribunal is very private. Not everyone can attend the tribunal. So, if the party needs support like technical support, like the connection about the preparation of the equipment, so it must be allowed and then permit from the tribunal. The third party, as referred to paragraph number 2, is obligated to make a non-disclosure statement that stating the third party will maintain the confidentiality of the hearing. And then the chapter number 4. At the last 3 days before the implementation of the hearing, according to this rule and procedure, the parties can carry out technical preparation for the hearing. And then the procedure of the hearing by providing equal opportunities to the parties. In chapter number 5, about the evidence, document, witness, expert, and award, the evidence verification process is carried out physically. I mean, they have to meet and attend online, offline, or the stipulated accompanied by the preparation of a record of the verification. And then the chapter 6 about other provision. The provision related to the electronic arbitration which are not regulated in the rules of procedure as well as the BANI arbitration rule shall be further determined by the BANI governing board. And for the implementation of this rule and procedure, the BANI governing board can create standard form which are an integral part of this rule and procedure. Actually, this regulation already applied since 2020 when the COVID-19 attacked us. So, but right now already as an official and then as a formal regulation that to be uh, become a formal procedure from BANI if a party want to select the way of to resolve their dispute, yeah. But there is only option also if we want to use the what we call it hybrid arbitration process, yeah. Sometime if we want to use the online app, another session of the process, we can attend face to face in the tribunal. Then, okay, next. So if we are talking about digital economy and settlement dispute, the important about the digital economy regarding to...
I'm so sorry, Dr. Rizal,
Yeah.
we only have 2 minutes left.
Okay, regarding to the digital business, it is a huge problem because if the customer have a dispute with the seller, suppose using the application like Shopee, Tokopedia, it is still a big issue how to resolve the dispute among seller and the customer. So actually the application already perform a resolution dispute with their platform, but how about if the buyer or the customer not satisfied for the resolution of the platform? Can they go to the mediation or can go to the arbitration? It is still a problem and still as a big issue in Indonesia. Next please. Next. Arbitration and mediation of e-commerce in global competition. Yeah, it is a cross-border. Exactly. Electronic transaction and e-commerce are cross-border. And then the choice of forum. The parties have the right to choose a forum in accordance with the principle of international civil law. And the competition. Mediation and arbitration institutions in various countries compete to become a forum for resolving e-commerce dispute right now. And then the digital platform and collaboration. BANI needs to create a digital online dispute resolution platform for e-commerce dispute and collaborate with electronic system organized. And then the regulation. The regulation is needed to encourage the use of national mediation and arbitration forum as the forum of resolving digital business dispute. Actually, I want to explain about the AI also in this forum, but because of the limitation, I want to split it and then go to the last slide, please. The content regulation of new, before that, yeah. The content regulation of new arbitration and mediation in digital era. For online dispute resolution, we have to pay attention to the procedure, the validity of electronic evidence, and electronic arbitration and mediation. This is the issue. And then about the data security and privacy. Yeah, provision of data security is very confidentiality. And then AI and arbitration. AI ethic in mediation and arbitration is necessary. And then the decision is made by human arbitrator. AI is only a supporting tool. Yeah. And for recognition of online dispute resolution as a equivalent decision to offline arbitration. And then last but not least, digital platform, trustworthy cybersecurity is very important. Thank you. I think this is my presentation. We can continue to the question and answer in the next session. Assalamualaikum warahmatullahi wabarakatuh.
All right, thank you so much for the amazing presentation from Dr. Insinyur Haji Ahmad Rizal. Okay, let me give you some summary from the last presentation. The digital era presents both challenges and opportunities for arbitration in Indonesia, while issues like data security, privacy, and technological inequality pose risks to adoption of online arbitration, especially through initiatives like BANI electronic arbitration rules. Over faster, more efficient, and globally accessible dispute resolution mechanism. The strategic integration of artificial intelligence and adherence to ethical guidelines are essential. Alright, ladies and gentlemen, let's move on to our last speaker, but not least, Dr. Meria Utama, SH LL.M, or we can call me Mary. Dr. Meria Utama is an associate professor, Faculty of Law, Universitas Sriwijaya. Dr. Meria is a distinguished legal scholar with a strong background in international law. She earned her law degrees from Universitas Sriwijaya, Erasmus University Netherlands, and Universitas Pajajaran. Graduating with a perfect GPA, her leadership roles include Vice Dean II, Executive Secretary at BANI Arbitration Center, and Head of the International Law Division at Universitas Sriwijaya. She also founded the Cahaya Rabbani Foundation at the ASEAN Law Students Association. Dr. Meria actively promotes international legal education, serving as faculty advisor at global MUN events, and participating in conferences and trainings worldwide, including a practicum at the International Court Justice. But currently right now, Dr. Meria Utama is a Senator of Academic Affairs, Universitas Sriwijaya, Secretary of TPK, and Assessor of Research Unsri. Alright, ladies and gentlemen, please welcome our amazing speakers from Universitas Sriwijaya, Dr. Meria Utama, SH LL.M.
All right, thank you, beautiful moderator, Ms. Rai. And then, not morning anymore, I guess. It is good afternoon, everybody. Good afternoon. It is an honor to be a speaker, the last speaker here, but I hope you're still in here with us. Actually, the committee delivered a challenging motion on me about the smart contract and arbitration. Therefore, I read about these 2 days, studying about the smart contract actually. So, continued. Right, I would like to give you a question. Anyone here ever concluded smart contract? Ada yang pernah conclude smart contract? Anyone? Belum? Not yet? Or you are not realized that you are ever been concluded smart contract? Not realized, unrealized. Yeah, actually smart contract is very popular, but we are unrealized that we are also already concluded in the smart contract. For instance, you know the vending machine for the drink? You want to buy Coca-Cola on the vending machine? Yes, remember? And then you put money on it, and then suddenly the Coca-Cola came out from the vending machine. So that is a smart contract actually. Ah, see, yeah? Okay, and then have you ever buy some goods in the marketplace? Yes, yes, and then you just scroll, and then you tick agree, and then the goods delivered to your home. So it is a smart contract, yeah? So it's very common, and then you use maybe every day. The one who sometimes buying from Shopee, from GoFood, yeah, actually it is concluded by smart contract. But when we see my presentation, given 15 minutes from Ms. Rai, it's already 5 minutes going, yeah. The first is I would like to discussing about what smart contract, and then I also I already give you the explanation and then the example, and then the second is legal problems regarding a smart contract. I will be discussing about that. And then number 3, about the need for smart contracts dispute resolution. Is there any dispute resolution over there? Or you just go directly to the court? And then number 4 is about how smart contract dispute resolution works. And then the last is about, does arbitration perfect resolution for the smart contract? Continue. So, just now, Mr. Insinyur Rizal said that the using of AI, and then of course nowadays AI is a very, very important in our daily life. Whenever you like to chat something, you like to search something, you try to find in metadata, and then also you try to googling it, and then it is also in 5.0 society. Long time ago we used a typewriters, and then after that computers, and then change the vehicle also. Vehicles, long time ago you were using cart or motorcycle or even car. Nowadays the cars become electricity. Elon Musk said that he found that the car, you just using a remote after that, or you just give the order by your voice, and then the car directly go away and then move around. And then nowadays you use money, not money anymore, but it's become a Bitcoin. It's very popular in USA. So the idea of the smart contract was popularized by the computer scientist Nick Szabo, and then he suggested that many kind of contract can be embedded in computer software and hardware. Continue. So I divided the smart contract into early period and current period. The early period, like what I said just now, it is like whenever you are buying something in marketplace administrator, for instance. And then nowadays it's become more modern, especially there is an AI inside. Continue. So the application of the smart contract, actually there are many majors. The first is on the real estate, vehicle ownership. Currently you just buy the car by only on the platform, such platform in Indonesia. And then music industry, Spotify for instance, you just buy the music over there, you pay certain amount, and then they give you some of music access. And then the government election, maybe in Indonesia we do not implemented it yet, but in some other modern countries they already implemented smart contract in government election. Just push button and then your vote recorded. And then healthcare, of course. Continue. Why smart contract is mostly using? There are some benefit of that. The first is record keeping, autonomy, reduce fraud, fault tolerance, enhanced trust, and cost efficiency, of course. Continue. Now, this one is the potential benefit. Despite both potential benefits, there are also some problems on the smart contract. What about if the coding are errors? And then ambiguous or incomplete contracts concluded. And then external factors, the change of regulation in one country. What happened? What about that? And then number 4, some issues relate underlying blockchains, network, for instance, net contagion or security vulnerability. What about the hacker, for instance? What about your data? And then deployment costs vary depending on the factors of the deployment complexity. And then the last one is, what about if your contract is no longer your agreements? Yeah, it's suddenly changed by the system. Therefore, continue. Therefore, we need such kind of resolution about that. What kind of resolution using by the party? What is the what kind of remedy that the party can use? Is it okay to the court? Is it necessary if the parties go to the court? But it's very difficult because sometimes in smart contract we do not know the parties. We do not know the parties. It's confidential. Continue. So the need for the smart contract dispute resolution is, the first is, actually smart contract is a code. You cannot read the contract directly. It's just a code. I will show you later. And then the second is, the anonymous nature of the certain smart contract can make it difficult to determine the identity of the parties. Yeah, so this one is the obstacle. And then the last is, it is confidential. So the one who join a smart contract, the current smart contract, you sometimes don't know where they are, who they are, but you just put a certain money and then you can get the return of that. Yeah, so it's confidential. That's why, continue. Arbitration is a choice. Arbitration is a choice. Because arbitration has a final and binding award. Has a final and binding award. Yeah, so this is a choice. Compared to other dispute resolution. If mediation, you have to discussing blah blah blah. It's very difficult. In arbitration, if and then this one. If this one situation, then this one. Just like whenever you buy a ticket of the aeroplane, for instance, the aeroplane is late, then there is a termination say that if it is late for about 1 day, then your money will be returned. So, and then you sign it, and then you agree with that ticket's rules, and then whenever the aeroplane really late, then your money is returned. Yeah, so just like that. Legal issues on arbitration in smart contract. Continue. So there are 4, I divided into 4 legal issues on arbitration in smart contract. The first is the formation of the agreement. What about the agreement in the smart contract? Yeah, what about the agreement, arbitration clause in the smart contract? Mr. Rizal, Mr. Ilyana said just now that the clause must be in written. So how to write arbitration clause in smart contract? The second is, what about the procedure? What about the procedure? And then what about the seat of the arbitration? So because this is so related with the enforcement of the arbitral award. That's for number 4's problem is the enforcement of the arbitral awards. Next, continue. So the formation of the agreements, there are over and acceptance just like a normal contract, and then the capacity of the parties. So about the capacities of the parties is depend on the machine. So if you write that you are under 17 and then that suddenly the system will be rejected. But if you write you are above 17, then the system will be approve you to be the member of the smart contract. So capacity of the parties is depend on what you write and then what you give information to the system. And then continue. What about the international convention regulation? What about New York Convention? New York Conventions agree with this? Yes. Actually, New York Conventions can deal with this because it is flexible in interpretation, in writing, communication, and then it is accessible and usable for subsequent. Yeah, and then also UNCITRAL. UNCITRAL also agree with this kind of code for arbitration clause, although do not state it directly to the regulation. And then what about the local law? What about Indonesia? Indonesia still try to find what is the rule, what about the regulation about this? What about the regulation about this? So Indonesia just discussing about this contracts, smart contracts in IT, information and technological regulation only. Continue. This one is the example of requested arbitration, just like that. Smart contract, you see just the code over there, contract details, but inside is your agreement that there is what we call term and condition, and also arbitration clause. So this one, SIAC model clause. It is for traditional arbitrations process. So for the smart contracts, the what we call the arbitration clause is just a code. Continue. This one is dispute resolution for smart contract. This is the diagram. Yeah, smart contract send result to the parties, and then grace period if there is a dispute, and then if the parties raise objection, then arbitration library triggers arbitration, and then finally there is a result, dispute resolution is being performed, and then it is back to the contract. Yeah, it is back to the contract. So it's just like a simple. So I divided into on-chain and off-chain mechanism. Continue. What about the seat of arbitration? Because this is on the system, we do not know the seat of arbitration. So the questionable is about the arbitral award enforcement and recognition, of course. Next, continue. Now, what about the rules? Yeah. Because this is the mention, some questions is about the fairness of the parties, and then also the arbitrator is anonymous. We don't know who is the arbitrators, or in some platform you can appoint the arbitrators. You can appoint the arbitrators. They give the name or give the code about the arbitrators. So continue, Pak Mujib. All right, just like this. I almost come to an end. Yeah, smart contract arbitration can be integrated through on-chain or off-chain. If Pak Rizal just now mentioned about the hybrid of the arbitration, it is online and then it is offline. So it's quite the same. It is on-chain and then it is off-chain. If the problems is really relate to the smart contract, then on-chain can be implemented in settling the dispute. But if seems that there is another factors over there, so the parties can suggest it off-chain arbitration. But of course, it's will be related to the confidentiality, because sometimes in smart contract the parties are hiding their personal data or information. So for instance, I myself become the parties, so I have a code, my name is not Maria Utama, but XYZ and 0, for instance, just like that, yeah? Okay, and then the last is about the arbitral awards and enforcement. Is it affect the awards? Yes, of course, yeah, yes, of course, by system. And then it is enforceability, and then legally binding arbitration in smart contract, just like the arbitration rules, traditional arbitration rules. And then produce res judicata. So if in online or on-chain already settled, you cannot bring the case to the court anymore. It is already res judicata. And
I'm
then,
so sorry, ma'am. We only have 2 minutes left.
yes, okay, one more minute.
All right.
Okay. I give the some recommendation. There is a great importance of having some kind of dispute resolution in smart contract, and Indonesia actually must be really deal with this. And then so maybe there is an additional regulations of government regulation or any regulations that stipulated about the smart contract and dispute resolution. That's all my presentation today. Thank you very much for your attention. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you so much for the inspirational presentation from our beautiful speakers. Alright, let me give you some summary about this last presentation. The adoption of smart contracts and blockchain is significantly modernizing arbitration by streaming process, enhancing transparency, and ensuring more secure and reliable outcomes. These technologies offer a practical and innovative approach to handling dispute in digital era, making arbitration more accessible, efficient, and trustworthy for parties across borders. All right, ladies and gentlemen, right now we are in the last session of our international seminars. But before we continue, I want to say hi with Mr. Manteng Yong. Do you still with us, Mr.?
Yes.
All
Yes,
right. All right, Mister. So right now we are in the last session. It's question and answer. So I want to say hi with the online audience too from Palembang University, and then I see it's from BANI, Badan Arbitration Nasional. All right. Okay. Good afternoon, everyone. So for everyone in online and offline, especially in online, you can raise your hand and then you can chat, and or maybe you can on your microphone if you wanna ask something with all of the speakers in here. And for all of you, the offline audiences, you can raise your hand, say your name, your institution, what is your question, and for who your question is. All right, ladies and gentlemen, I'll give you time for asking for all of the speakers. All right, oke, silakan Pak. Ya, yang di belakang. Alright, thank you.
Terima kasih. Assalamualaikum warahmatullahi wabarakatuh. Salam sejahtera bagi kita bersama. Saya mohon bantuan dari moderator karena saya nggak bisa bahasa Inggris. Jadi tolong ditranslate aja, boleh? Ini gaya ibu, gaya orang Malaysia, Bu Liana, Pak Walid ya, lagi heboh sekarang nih. Ini terkait dengan Pak Rizal sebenarnya. Saya melihat ada perkembangan regulasi dari BANI ini. Artinya BANI ini kalau suatu perjanjian tidak dicantumkan persoalan penyelesaiannya ada BANI di sana, itu tidak bisa dilakukan mediasi. Itu pertama yang ingin saya tanyakan, regulasi dari BANI terhadap Pak Rizal. Kemudian saya melihat teknologi ini sangat berguna sekali untuk kemajuan, untuk juga transparansi, kemudian hal-hal lain yang kepentingannya untuk umum. Tetapi kemajuan ini, apakah kita tidak melihat dari sisi sosialisasi, dari sisi kemampuan dari masyarakat untuk menyerap teknologi ini? Saya contohkan saja, kita punya teknologi di perbankan, katakanlah itu namanya aplikasi. Mungkin kalau di Bank Mandiri ada Livin, kalau di bank-bank lain ada macam-macam. Teknologi ini itu sangat bagus, baik sekali untuk kepentingan masyarakat. Tetapi persoalannya ketika ada oknum yang bermain, ketika masyarakat yang tidak mampu mengupdate dari aplikasi ini, uangnya bisa hilang di dalam aplikasi tersebut. Nah, saya contohkan aja, itu kasusnya lagi viral, saya pegang kasusnya. Nama saya Irwansah, saya dari Universitas Taman Siswa. Kebetulan juga saya sekretaris umum Asosiasi Pedagang Pasar seluruh Indonesia. Nah, jadi persoalannya, Bu, nilai kepercayaan dari kita, masyarakat umum, kepercayaan kita terhadap perbankan. Kemudian oknum perbankan yang punya jabatan, kepala cabang, datang ke rumah kita. Saya pedagang, kemudian saya dari uang-uang kecil-kecil saya kumpulkan sampai 1,8 miliar ada di bank saya. Kemudian oleh perbankan dipindahkannya ke deposito. Setelah beberapa bulan kemudian dipindahkannya lagi ke tabungan. Tetapi tabungan ini aplikasinya di tangan oleh orang oknum perbankan. Dia datang ke rumah saya, kemudian dia bilang, "Pak, saya bantu nih buat aplikasi supaya Bapak lebih lancar." Kebetulan saya gaptek, hanya pintarnya nelpon dengan menerima telepon, tidak ngerti sama sekali. Nah, ketika persoalannya duit 1,8 miliar saya dilenyap di perbankan karena aplikasi tadi. Jadi dia membuat aplikasi di nomor oknum perbankan, di nomor oknum perbankan aplikasi tersebut, uangnya hilang, pindah ke rekening lain. Nah, ini kan persoalannya, teknologi ini harus juga mengantisipasi sosial masyarakat, kemampuan masyarakat. Jangan hanya kita bicara teknologi, tetapi kemampuan masyarakat menyerap teknologi ini berbahaya. Bayangkan saja, dari 100-200 ribu sampai 1,8 miliar dikumpulkan uang oleh masyarakat kita, pedagang kita, tetapi hilang dalam sekejap oleh teknologi ini. Nah, saya berharap BANI juga mampu menyerap persoalan ini. Terima kasih, mohon maaf. Bagaimana hukum bisa mengantisipasi persoalan ini? Terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Alright, thank you so much for the question, sir. For Dr. Ahmad Rizal, you can answer the question from. Langsung aja nggak apa-apa. Nggak apa-apa, langsung aja. Biar cepat.
Yes. Thank you, Mr. Irwansyah. No arbitration without agreement, itu salah satu. Ya. Jadi tidak akan ada proses arbitrase yang dilakukan oleh lembaga manapun juga, apalagi BANI, kalau tidak ada perjanjian tertulis, ada klausula tentang penyelesaian arbitrase, bukan di pengadilan umum misalnya. Jadi harus ada tertulis di klausula itu bahwa proses penyelesaian sengketanya melalui arbitrase dan menunjuk BANI sebagai lembaga yang menyelesaikannya. Itu harus ada. Apabila tidak ada hal tersebut, maka tidak ada kewenangan absolut dari BANI ataupun majelisnya untuk memutuskan. This is important about authority absolutely. Kalau tidak ada itu, Pak, mohon maaf, tidak akan ada di proses arbitrase. Kalau ada juga dilakukan, berani-berani dia bisa dibatalin orang pasti di pengadilan atau di Mahkamah Agung. Itu yang nomor satu, bahwa harus ada perjanjian tertulis antara kedua belah pihak. It is party autonomy to choose, to select, the choice of forum. Itu hak para pihak. Kemudian mau pilih choice of law, seat of arbitration, itu nomor sekian. Tapi yang nomor dua itu adalah party otonomi untuk memilih choice of forum. Nah, itu. Jadi sekali lagi tidak ada pilihan itu dan tidak tertulis, maka tidak akan ada proses arbitrase. Kemudian mengenai teknologi, betul Pak, kita sangat kalau yang Bapak ceritakan tadi itu soal spam itu adalah penipuan. Tapi kalau di proses arbitrase, bukan itu yang kita takutkan. Yang kita takutkan adalah karena sifatnya rahasia dalam proses persidangan, itu sangat dijunjung tinggi. Kalau misalnya kita sidangnya di ruangan, terlihat siapa yang masuk, principal or kuasa hukum. Nah, bagaimana kalau dalam online dia berhadapan di depan kamera, sementara di kiri kanan ada orang? Maka si arbitrator harus announce to the party, para pihak, Anda yang boleh hadir hanya yang berhak hadir. Namanya disebut 1, 2, 3 sesuai absen. Apabila ada pihak lain di luar ini yang menghadiri itu dan proses ini bocor, maka ada undang-undang Republik Indonesia yang dilarang, yaitu undang-undang tentang ITE. Ancaman pidana kalau ada pelanggaran undang-undang ITE. Maka apabila salah satu pihak ternyata mengetahui ada pihak lawannya, ternyata ada pihak yang hadir dan memanfaatkan data-data tersebut, tadi saya sampaikan itu penting, data security, maka dia akan kita kenakan pelanggaran pasal pidana soal undang-undang ITE. Jadi pilihan ada mereka mau dikenain pasal pidana atau tidak. Maka good faith itu penting Pak dalam proses arbitrase. Number one itu adalah itikat baik, good faith among party. Kalau tidak ada itu, salah mereka pilih arbitrase. Arbitrase itu adalah kehendak para pihak untuk mencari keadilan, bukan untuk mencari kemenangan. They need a justice. Bukan untuk menang-kemenang. Mungkin itu yang harus saya sampaikan, bukan soal spamnya, tapi bagaimana mengatur agar hanya pihak-pihak yang memang bisa hadir itu yang boleh hadir di dalam ruangan untuk online. Karena tempatnya kan satu di mana tidak bisa kontrol ya. Kita kontrolnya, ngaturnya dengan pelanggaran yang akan mereka lakukan, itu akan ada sanksi hukum. Demikian, terima kasih.
Alright, thank you so much, Dr. Insinyur Rizal. Alright, maybe we move on to the next question. Okay, come on. Yeah.
Okay, thank you for thank you for the opportunity. But first of all, let me introduce myself. I'm Karenina Fernandia, and I'm on my 3rd semester right now on Faculty of Law, Universitas Sriwijaya. And first of all, I really want to giving my beloved thank you to all of the honorable speakers, and I'm totally amazed by your seminar today, especially because I'm really interested on international law. So this seminar is spectacular for me, and I have 2 questions actually, if it is allowed. So my first question is, this is directed to the first speaker, Sir Mai Teng-yong. Okay, so my question is, how can the regulatory framework for traditional Chinese medicine, or like we know TCM in Macau, serve as a model or point of reference for developing comprehensive health law policies regarding traditional and complementary medicine in Indonesia? Because I really want to know the relevancy between both of the law, because the focus on today's seminar is international law. And my second question is, to be honest, is not directed to, this is really directed to the Honorable Memeli, but this could also answered by all of the speaker, because my question is, how could we differentiate the problems, especially with smart contract on this era? Because most of the general young citizen, including me and my friends in here, doesn't even know actually the relevancy between arbitrate and smart contract. And that is my question. Thanks a lot once again. I'm totally amazed by all of your sessions today. I really hope that I could improving myself more with your answers today. And thank you for your participation, especially the one that came far away, not from Indonesia. Thank you.
All right, thank you so much, Karenina. For Mr. Man Teng-yong, you can answer the question from our audiences.
Yes.
All right, okay. Time is yours.
Okay, for the question about the law in Macau, especially for traditional Chinese medicine, actually we have, if you don't mind, let me share the law here. I hope you can see the law here, but only in Chinese or in Portuguese. Here I show you the Portuguese version. I will not explain one by one, article one by one to you. I just want to show you more and less the picture about the traditional Chinese medicine law in Macau. For example, here we have important regulations here at the beginning. Especially, we need to define what is the ambit. What is the ambit? This number 1 article is very important because, for example, in Portugal, Portugal is one of the European country that recognize superior education about traditional Chinese medicine, but they do not call traditional Chinese medicine as doctor. They call them as professionals. So in Macau is very different. We call traditional Chinese medicine as doctor. So this is the difference between Western countries and the situation in Macau or Chinese community. So the ambit is very important for us to know if we can call them as doctors or not doctors. In Macau we call them as doctors. And also we need to have some definitions to define what are the activity, especially pharmaceutical activity in traditional Chinese medicine, and how to register the medication of traditional Chinese medicine, and more and more. These definitions are very important for us to have a law regarding traditional medicine, or that includes not only traditional Chinese medicine, can be the traditional medicine in Indonesia also. I'm not sure if Indonesia is statute law or something like that can define this or not. And also we need to have some principles, relevant principles, especially to how can we use traditional Chinese medicine to protect the public health in Macau. Public health is a point very important, especially we experienced COVID-19, right? During the COVID-19 period, we used, in addition to Western medicine, also we used traditional Chinese medicine to combat or to prevent the prevention of the virus. So traditional Chinese medicine also very important for protecting public health. And also more principle, especially in Macau, we pay more attention to the principle of legalization or legality. If the government do not have law to act, it means the government does not act with legality. So this principle of legality is very important for the government to act not only in public health issues but also in private health issues. So we have more, especially license of the pharmaceutical activity. We need to have, if I want to open a pharmacy about Chinese medicine in Macau, we need to have the license from the government. So we need to have the regulation about license, and also we need to have the license not only for the pharmacy but also for the practitioners, the doctors, I said. In addition to the institutions I call pharmacy or the clinic, we need to have the license for traditional Chinese medicine doctors. So this is the picture of the situation of traditional Chinese medicine here and traditional Chinese medicine law here in Macau. I'm not sure if I reply all of your questions or not.
All right, Ms.
Dewi, Pak. Oh, lantai 4 ya.
All right, Mr. Mantegno, thank you so much for the answer from the question. Okay, for the next question, it will be answered by Ma'am Mary. Time is yours.
Karenina, right? Thank you very much for your question. Yeah, it is good that the third semester students can ask this question. So actually, whenever we are talking the smart contract, the system is not immune. It is vulnerability. Yeah, so sometimes also increasing the dispute, of course. So that's why we are trying to selecting some dispute mechanism. Therefore, the selecting arbitration is the best process, I guess. Yeah, that's why some of the platform also choosing arbitrations to settle the smart contract dispute. That's because they are regulatory framework, yeah. So they are also involving and may vary across jurisdiction. So it is enforceability in every country, and then also it is faster resolution. Faster resolution. If you met certain condition, then the resolution is just like this, and then it is enforceable. So that's why smart contract mostly together with arbitrations. Yeah, okay, thank you.
All right, thank you so much for the answer from Ma'am Mary. All right, ladies and gentlemen, because of our limited time, so I can see your tired face in here. Okay, thank you so much for all of you. But before we closing our session, I want to giving 2 books for 2 questioners. So for Karenina and Dr. Irwansyah, please come forward with us to be here. For Dr. Iliana and Dr. David. Okay, all right, thank you. Okay, okay. All right, all right. Oh yeah. Thank you so much for Dr. Iliana dan Dr. David for a symbolic giving books for the questioner. All right, ladies and gentlemen, we have reached the end of our event in our international seminars. Let me confuse some conclusion about our international seminars. In the era of the Society 5.0, the greatest challenge in arbitration is not just resolving dispute efficiently, but transforming traditional practice to keep pace with rapid technological advancement, ensuring the fairness, transparency, and justice remain intact in an increasingly digital and interconnected of the world. Alright, good afternoon ladies and gentlemen, I'm Resita Diljanda as the moderator of this seminar, and I say goodbye. Thank you so much for your attention. Assalamualaikum warahmatullahi wabarakatuh. I'll hand it over to the Master of Ceremony.
Our last session concludes all of our agenda for today. We would like to express our deepest gratitude to all the honorable guests and participants, speakers, and also our moderator.
Our biggest hope is that all of you can get the valuable learning from today's international seminar.
Lastly, I am Diva Maharani Putri and my partner,
Arbitration Shahrul Ramadan, send our farewell and
we'll see you in another opportunity.
Wassalamualaikum warahmatullahi wabarakatuh. To all audience, you may be pleased to stand up for the photo session with the speaker.
We invited all the speakers to have the group photo.
Audience may be pleased to stand up for the photo session. Boleh berdiri teman-teman.
Untuk peserta, panitia menyediakan makan siang dan sertifikat yang bisa diambil di meja registrasi. Untuk dosen-dosen akan diadakan makan bersama di lantai 7. Terima kasih.
Izin untuk semua tamu undang, harap barang-barangnya diperhatikan.